Somewhere in a drawer, a safe, or a filing cabinet, there's a piece of paper you signed decades ago that you assume will protect your family. Most people never check it again after the day they signed it. That single assumption is exactly what's putting an entire generation's estate plans at risk right now. And almost nobody born before 1966 has been told. 3 specific defects are quietly sitting inside wills written 20, 30, even 40 years ago. And any one of them can get a will thrown out in probate court. Not because the person's wishes were unclear, not because anything was forged, because the document itself no longer meets the legal standard required to enforce it. My name is Emma. I'm no expert, but I break down financial and estate information that helps you protect what you've spent a lifetime building. If that's useful to you, subscribe, because this is exactly the kind of thing I cover every week. One document, one loophole, one fix at a time. Let's get into it. If you were born before 1966, there is a real chance the will sitting in your files right now was drafted under rules that have since changed, witnessed in a way courts no longer accept without a fight, or written around a family situation that no longer exists. None of that means your will is definitely invalid. It means nobody has checked, and checking is the entire point of this video. 3 defects come up again and again in older wills, and every one of them is fixable in a single afternoon once you know to look for it. One involves who stood next to you the day you signed. Another involves what happens automatically the moment your life changes, whether you update the paperwork or not. The third involves a piece of financial planning most people don't even think of as part of their will, and it can override every instruction the will contains. Stay with me through all 3, because the last one is the quietest and the most expensive if it's missed. I work with people navigating exactly this stage of life, the part where the goal shifts from building an estate to making sure it actually reaches the people you intend. The people I talk with are not careless. They wrote a will when they were supposed to, they named the right people, and they filed it away and trusted the system to hold up their end. Trusting the system was the mistake. Not because anyone did anything wrong to them, but because the system itself moved and the paperwork didn't move with it. 2 groups are watching this, and both need to hear every section, because both are exposed in different ways. If you wrote a will decades ago and haven't looked at it since, the risk is that the document itself no longer meets today's execution standards, or no longer accounts for people and assets in your life who weren't there when you signed it. If you're the adult child of someone in that position, the risk lands on you later, at the exact moment you're grieving, in the form of a probate court telling you the will your parent trusted for 30 years doesn't hold up. Neither group gets to sit this one out. Let's talk about why this happens at all, because if you don't understand the cause, it feels random, and it isn't. Estate law is not federal. Every state writes its own rules for what makes a will valid, and states revise those rules more often than people realize, usually through updates to what's called the state's probate code. A will drafted in 1985 was written to satisfy 1985's rules. If your state has since tightened witness requirements, changed how self-proving affidavits work, or updated what counts as proper execution, your decades-old document is being judged today against a standard it was never built to meet. None of this gets announced with a press release. It moves through statute revisions, appellate court rulings, and bar association guidance that reaches attorneys, not the general public. A will that was airtight the year it was signed can become vulnerable years later without a single word on the page changing, because the bar it's measured against moved instead. Here's the part that matters most. Courts don't get to guess what you meant. If a will fails execution requirements, the document can be thrown out entirely, and your estate gets distributed under your state's default inheritance laws instead of your actual wishes. That's not a minor technicality. It can mean a stepchild you raised for 30 years gets nothing, while an estranged relative you haven't spoken to in decades gets a share, purely because the law defaults to blood relatives when there's no valid will to say otherwise. Let's look at what actually breaks first. Defect 1. The witness requirement. Nobody rechecks. Every state except Louisiana requires a will to be signed in front of witnesses rather than notarized, and most require 2. That part hasn't changed much over the decades. What has changed, quietly, is who's allowed to count as a valid witness. And that single detail is where older wills fall apart. Most states disqualify what's called an interested witness, meaning someone who stands to inherit under the will they just watched you sign. Decades ago, this rule was applied loosely in a lot of households. It was common, even normal, to grab whoever was nearby, a family member visiting for the holidays, an adult child home for the weekend, and hand them a pen. If that witness was also named as a beneficiary, many states today will either void their inheritance, void the entire will, or force a court hearing to sort out which rule applies in your specific state. Take a man named Harold. He's 78, a retired machinist from outside Cleveland, and signed his will in 1988 with his 2 adult children as witnesses, because they happened to be visiting that weekend. Both children were also named as beneficiaries. For 36 years, nobody thought about it twice. When Harold passed last year, the probate court flagged the will immediately. Ohio law treats a beneficiary witness as presumptively receiving an improper gift, unless they can prove no undue influence occurred. Harold's children spent 4 months and several $1,000s in legal fees, proving what should have been obvious, that their own father wrote his own will without anyone pressuring him. The will itself was never in dispute. The witnesses sitting inside it were. There's a genuine upside once you know this. If your will is still unsigned, or you're updating it anyway, choosing 2 witnesses who inherit nothing under the will removes this entire category of risk permanently. If your will was already signed decades ago and you're not sure who witnessed it, that's knowable, and it's worth finding out before a probate court finds out for you. The mistake people make most often here isn't carelessness. It's assuming that because a will was accepted without objection when it was signed, it's protected forever. A will isn't tested the day you sign it. It's tested the day you die, against whatever standard applies at that moment. Start this week by pulling out your actual will and reading the signature page, not a summary, the real document. Identify who signed as a witness. Cross-reference their names against who's named as a beneficiary anywhere in the will. If there's overlap, that's not necessarily fatal, but it's worth a single conversation with an estate attorney in your state to find out whether your state treats interested witnesses as disqualifying, reducible, or curable. That conversation costs far less than what Harold's children paid. Underneath the witness question sits something even less visible, something that changes automatically whether you touch the paperwork or not. Before we move to the second defect, go find the actual document, not a copy you think exists somewhere. The physical will with the original signatures. Look at the date on it. What I'm about to explain is going to change how you read that date. Defect 2, automatic revocation you never consented to. Most states have what's called an automatic revocation by divorce statute, and a smaller number have similar rules for marriage. In plain terms, if you divorced after signing your will, many states automatically strike out any provision naming your former spouse, whether you ever updated the document or not. The law assumes you wouldn't want an ex-spouse inheriting, so it edits your will for you. That sounds protective, and often it is. The complication is what it does to everything built around that provision. If your former spouse was also named as executor, or as the backup guardian for a beneficiary, or their share was supposed to flow to specific people if they predeceased you, striking that one clause can leave a structural gap the rest of the will was never written to handle. The will doesn't just lose a beneficiary. It can lose the person who was supposed to run the whole thing. Consider a woman named Evelyn, 71, a retired school teacher from outside Richmond, Virginia. She married in 1979, wrote a will in 1983, naming her husband as sole beneficiary and executor, and divorced him in 1996. Virginia's revocation statute automatically voided his inheritance the moment the divorce was finalized. Nobody told Evelyn this happened. She simply assumed her old will was void entirely, and that she'd need to write a new one eventually, so she never got around to it. When Evelyn passed away last year, her family discovered the 1983 will was still technically valid, minus the one clause naming her ex-husband. With no executor named and no alternate beneficiary listed anywhere in the document, the court had to appoint an administrator and distribute her estate partly through the will and partly through Virginia's intestacy rules, a split outcome nobody intended and nobody chose. The upside here depends heavily on your situation. If your life life circumstances haven't changed since you signed your will, no divorce, no remarriage, no death of a named executor, this particular defect likely doesn't touch you. But if any major life event happened after you signed and you never revisited the document, the automatic revocation rule may have already edited your will without your knowledge. And the question is only how much structural damage that edit left behind. The mistake people make with this rule is treating "the law already handled it" as the same thing as "my estate plan still works." The law only strikes what it's required to strike. It doesn't rebuild what's missing afterward. That part is still on you. What to do this week. List every major life event since you signed your current will. Marriage, divorce, remarriage, death of a spouse, death of a named executor or guardian. For each one, ask whether that person still appears anywhere in your will with a role or a share. If the answer is yes, and the event should have changed that, or if the answer is no, and nothing was named to replace them, that's a gap worth closing with an attorney, rather than assuming state law quietly fixed it for you. There's a related trap I want to flag before it costs someone real money, and it's not one of the 3 headline defects, but it destroys more estate plans than either of the 2 we've already covered. The overlooked piece. Beneficiary designations override your will entirely. Your will controls what it names. It does not control your life insurance policy, your 401k, your IRA, or any account with a payable on death or transfer on death designation attached to it. Those assets pass directly to whoever is named on the account's beneficiary form, regardless of what your will says, and regardless of how recently you updated the will itself. This is the single most common reason a well-written, perfectly valid will still fails to do what someone intended. A man rewrites his will in his 70s to split everything evenly between his 3 children. His 401k, opened decades earlier at his first job after college, still lists an ex-girlfriend from before his marriage as sole beneficiary, because he filled out that form once in his 20s and never touched it again. The will is valid, the witnesses were fine. None of it matters because the retirement account was never controlled by the will to begin with. The fix costs nothing and takes about 20 minutes. Contact every retirement account, every life insurance policy, and every bank account with a payable on death designation you hold, and request a current beneficiary summary in writing. Compare that list against your will. Update any form that no longer matches your actual wishes. This single step, done once, prevents more inheritance disputes than any clause you could add to the will itself. Defect 3. Formatting and language that no longer meets the standard. The third defect is the quietest, and it's the one most people never think to check because the will looks fine on its face. Older wills were often drafted using boilerplate legal language, references to trusts, guardianships, or property arrangements common decades ago, some of which has since been restructured or reinterpreted by courts in ways that change how the document gets read today. A will written in the 1970s or 80s might use per capita language to describe how a deceased beneficiary's share gets redistributed, assuming everyone understood it to mean one thing, when the state's default interpretation of that exact legal phrase has since shifted under updated probate code. The words on the page never changed. What they legally mean did. Take a woman named Ruth, 82, a retired librarian from a small town in Pennsylvania, who wrote her will in 1979, leaving her estate to her 3 children, or their issue, per stirpes. One of her sons predeceased her, leaving 2 children of his own. Ruth's 1979 will was drafted under an older interpretation of that phrase that her attorney at the time understood clearly. By the time Ruth passed, Pennsylvania's default construction of per stirpes distribution had been clarified by updated statute in a way that changed how the deceased son's share got divided among his 2 children, versus how Ruth's attorney originally intended it 45 years earlier. The estate wasn't lost. The distribution simply didn't land the way Ruth believed it would when she signed the document, and her grandchildren received a different split than she'd assumed for 4 decades. The upside, once again, splits by situation. If your will uses plain, modern language, naming specific people by name, rather than relying on legal shorthand phrases, this defect is far less likely to touch you. If your will leans on inherited legal boilerplate from decades ago, especially phrases like per stirpes, per capita, or references to issue and heirs at law, it's worth having an attorney confirm those terms still carry the meaning you originally intended under your state's current code. Read your will's distribution section slowly this week, and highlight any phrase you couldn't define in plain English if a family member asked you to. That's not a flaw in you. It's a flag for a 5-minute conversation with an attorney who can tell you whether that specific phrase still means what you think it means under today's law. What to do this week. None of the 3 defects above require rewriting your entire estate plan from scratch. Each one is a specific, narrow thing to check, and each one takes far less time to fix than it would take your family to untangle in probate court after the fact. Pull your actual will and check the witnesses first. If either witness is also a named beneficiary, find out whether your state treats that as disqualifying and get it corrected if it does. List every major life event since the will was signed: divorce, remarriage, a death among named executors or guardians, and confirm the document still names someone alive and legally able to serve in every role it requires. Request a current beneficiary summary from every retirement account, life insurance policy, and payable on death account you hold, and compare it against your will's intentions. Update any mismatch immediately. Read the distribution language in your will out loud. If any phrase relies on legal shorthand you can't explain in plain terms, get it reviewed by an attorney licensed in your state before assuming it still means what it meant the day you signed it. I want to be clear about something before you go. None of this is a substitute for actual legal advice, and estate law varies significantly by state, so a licensed estate attorney in your state is the only person who can tell you with certainty whether your specific document holds up. What this video gives you is the list of exactly what to ask them, so that conversation takes 20 minutes instead of 2 appointments. Every one of these checks is a phone call, a form, or a folder of paperwork you already have sitting somewhere in your house. None of it requires guessing, and none of it requires waiting for a family emergency to find out the answer the hard way. The best time to check was the day the law changed. The next best time is today, before the next envelope from your bank or your attorney's office becomes the thing that tells you what already happened without your knowledge.